This is E.T. In late 1787, the U.S. Constitution was drafted and months later ratified by 11 of the 13 states. Now that's more than a quorum. 2 states held out for some amending, particularly related to certain rights and also a greater degree of state sovereignty. Those who drafted the original Constitution purposely did not include the rights we see later in the first 10 amendments, the Bill of Rights. That was because Congress obligated to uphold principles spelled out in the Preamble, principles to form a more perfect union, ensure domestic tranquility, provide for the common defense, promote the general welfare, secure blessings of liberty to ourselves and our posterity, that we must, on occasion, violate, say, freedom of speech and the press to defend those principles that we see in the Preamble. And Congress will and has done just that. More about that in a moment. To political theorist Professor Wilmer Kendall, inclusion of a Bill of Rights, abstract freedoms to, for instance, elicit any words in any context, well, that was a bad idea, and it remained so. The Bill of Rights was to Kendall an afterthought, equivalent to, as he put it, some jerry-built lean-to set aside the original Constitution. As to the open violations of the Bill of Rights, well, the second U.S. president, John Adams, did just that, and that was only months after their ratification. It was when he promoted and signed the Sedition Act that defined as a high crime or misdemeanor any conspiracy against legal measures of the government, any interference with federal officers, any insurrection or riot, any writing, publishing, speaking, anything considered false, scandalous, and malicious against the government or any of its officers. Granted, only 10 men were convicted, mostly from the opposing Republican Party, and the sentences were pretty light. Or consider so-called Honest Abe Lincoln. During the Civil War, he suspended the writ of habeas corpus. Now that's a right guaranteed, habeas corpus, in the Constitution's body. And keep in mind that power of suspension of it belongs only to Congress. Well, it resulted in the imprisonment of between 2,000 and 13,000 civilians. Figures differ. What about World War I? President Wilson promoted and signed legislation that fined and imprisoned about 1,000 people, including a congressman, Victor Berger. That was for his remark that the war was, to use Berger's words, a capitalist conspiracy, which subsequent scholarship has shown it may well have been. And what about presidential candidate Eugene Debs? He was imprisoned and fined for his remarks that, and I'm quoting the judge, had a tendency to bring about resistance to the draft. And today, under a myriad of so-called anti-terror acts, Americans' rights are seen more as, well, contextual privileges rather than liberties. So Kendall was correct in pointing out that Congress is duty-bound under certain conditions to limit certain rights when the principles of the Preamble are threatened, and it has and continues to act in contradiction of rights. It's a magnification of Justice Oliver Wendell Holmes' dictum that went like this: freedom of speech would not protect a man in falsely shouting fire in a theater and causing panic. However, the First Amendment and the rest of the Bill of Rights became, via the amending process of the Constitution, an equal part of it. And the First Amendment reads, Congress shall make no law abridging the freedom of speech or the press. And no law means, as Justice Hugo Black wrote, no law. The debate over freedom of speech and later press is as old as ancient Athenian Greece, and a case can be made for both freedom and restriction of rights under certain circumstances. We may agree, for instance, that medical experts should have final say regarding medical care. But what if these experts disagree and they all bring forth studies to prove their respective positions? Or what if they're on the take? They're being bribed, otherwise influenced, to take a position that advances their own but not the public's interests. This is where an open society with unrestricted access to information is the most likely to allow you and me to determine what's in our interest. Now, that's something we did not see during the recent virus crisis. The freedom of speech and press is an ongoing debate. It's never going to cease. But the American people have had and continue to have, well, a presumption favoring open access to reading, hearing, and viewing whatever's out there via all media. And they tolerate restrictions only under the most extreme of conditions. Questions they ask, however, are just how extreme are those conditions? Are they extreme simply because a U.S. president or a government doctor say they are? Well, you may have thoughts regarding these questions, so type in your comments below. And do subscribe and share these videos. Thank you.